Hey guys, we have got 2 lectures to get through this week, so bear with me. You can watch these multiple days, the same day, however you'd like, and I'll post them both on the same day. Your quiz is due on Wednesday. Thank you to everybody who has gotten that in so far. There are some of you who still need to get that done. It will expire on Wednesday, so be sure and get that submitted. Next, we get 2 lectures this week. We have, we'll talk about fundamental American liberties today and the struggle for equal rights next. And you have your first exam next week. It will be very similar to your quiz. It's just kind of your quiz is a little bit of a practice on how to take a test in Blackboard, which maybe you've already done. It's gonna be the same sort of thing where you go in, it's gonna be multiple choice, just more questions. I posted the link for the site where you can practice questions for your textbook. That is hopefully helpful. Check those out for all of the chapters that we will have talked about up until this week. It will be, from my notes, it'll be chapters 1 through 6, but if your textbook, the chapter numbers may be a little bit different, so it'll be up until the struggle for equal rights. All right, so the chapter starts out talking about what's at stake in regulating gun ownership, and that's something that Congress has or that politics has struggled with for a long time. In 2012, there was a school shooting at Sandy Hook Elementary. I was actually working in Congress at the time, and I remember thinking, like, who is safe if our elementary school students aren't safe? It was really a terrifying thought. We had President Obama at the time who vowed to outlaw assault weapons. He formed a task force on gun violence with Vice President Biden leading it. He proposed that Congress would pass legislation banning assault weapons and requiring universal background checks on gun purchases, and limiting magazine capacity. There was a former Congresswoman, Gabby Giffords, who had been shot in the head in a mass shooting in Arizona. She formed a group called Americans for Responsible Solutions. Former New York City Mayor Michael Bloomberg formed a group called Everytown for Gun Safety. There was the Brady campaign to prevent gun violence. They had record donations coming in, yet nothing happened. John Boehner was Speaker of the House at the time, and he cried all the time when he was Speaker, but he went up, expressed a lot of regret, but he could not promise action because he couldn't promise action. It was hard. Gun rights are something that's extremely difficult to regulate. So the Senate did compromise on a bill on background checks, but it ended up failing, and it did never make it to the House. So what can you do? What's at stake in regulating something like gun ownership? Americans put a lot of stock in their freedom, certain that they live in the least restrictive country in the world. But collectively, we live in a government, which means we aren't free to do what we want. We have limits on our freedom that allow us to live peacefully with others instead of chaos, like everybody doing exactly what they want. John Locke said, "Liberty does not equal license. The freedom to do some things does not mean we have the freedom to do everything." Deciding what rights to give up in joining a civilized society and what rights we retain, this is a great challenge of democratic government. Rights and liberties are freedoms and privileges to which one has a claim. Civil liberties are individual freedoms guaranteed to the people primarily by the Bill of Rights. They protect our right to think and to act without government interference, to express ourselves and choose our own religion. Some are shakier than others. The right to privacy rests on judicial decisions. Civil rights are citizenship rights guaranteed to people primarily in the 13th, 14th, 15th, 19th, and 26th Amendments that are protected by the government. This is usually an extension of government action. It usually means that the government must treat all citizens equally and apply laws fairly, not discriminate unjustly against certain groups of people. You distinguish between authoritarian government, which we talked about earlier, and non-authoritarian government, including democracies, because the citizens have the power to challenge a government if they believe it has denied them their basic rights. Democracies depend on the existence of rights. Civil liberties provide rules that keep government limited so that it cannot become too powerful. Civil rights help define who we, the people, are in a democracy and give those people the power necessary to put some controls on their government. We take many freedoms for granted. We speak confidently in our freedoms of speech, of the press, of religion, our right to bear arms, to a fair trial, to privacy, but none of these is inevitable. John Locke's writings during the Enlightenment brought about the first real discussions of rights at all. Nobody claimed rights against the government before that. Instead, they thought the government had all the power, and only gave subjects privileges they were willing to bestow. John Locke said the right to life, liberty, and the pursuit of property were conferred by nature, and that government should preserve natural rights of its citizens. This was central to the founders of American government. Practically speaking, a government can do whatever it wants as long as it remains in charge of the police and the military. But public opinion is outraged at the invasion of individual rights. Unless the government is willing to dispense with its reputation as a democracy, it must respond in a way to pacify public opinion, which can be a powerful guardian of the citizens' liberties in a democracy. A person who can successfully claim that he or she has rights that must be respected by a government is a citizen of that government. A person who is under the authority of a government but cannot claim rights is merely a subject, bound by the laws, but without any power to change or challenge them. This doesn't mean a citizen can always have things their way, nor does it mean that a non-citizen has no rights in a democracy. But citizens do have special protections and powers that allow them to stand up to government and plead their cases when they believe an injustice is being done. Sometimes rights conflict. Often for one person to get his way, another one must lose out. The first type of right conflicts occurs between individuals. One person wants to pray with classmates, another student doesn't want to be subjected to a religious practice against his will. Our right to know about who we elect might conflict with the candidate's right to privacy. Another way that rights conflict is when rights of individuals are pitted against the needs of society and the demands of a collective living. For example, the decision to wear a helmet or a seatbelt. It seems like an individual's decision, but society has an interest in regulating these behaviors because jeopardizing one's safety is costly to society in terms of loss of talent, wasted public investment in a person, cost of medical care. One of the most important aspects of claiming and defending rights is building and perpetuating a narrative that the rights you claim exist and that you deserve to have it. Often competing narratives, women have rights to their own health without government interference versus government must protect rights of the unborn. Guns are protected under the Constitution versus it's a privilege that the Constitution allows to be regulated. The NRA has controlled a narrative about guns very strongly so that any regulation is all seen as a death knell to gun ownership, though every right we hold is regulated in multiple ways. After 9/11, what a time to be talking about 9/11 right now, Americans were very afraid. So government federalized airport security and started screening passengers, searching luggage, and allowing armed agents on airplanes. They kept a close eye on folks suspected of things like having ties to patriotism. The 2001 Patriot Act made it easier for law enforcement to do many things like intercept email and conduct roving wiretaps. It allowed immigrants suspected of terrorism to be held for up to 7 days and sometimes indefinitely without being charged. The Bush administration issued an executive order that non-US citizens arrested on terrorism charges could be subject to a military tribunal where due process doesn't apply. The NSA, the National Security Agency, began collecting a lot of data from phones and emails of foreign and domestic individuals. This may have increased the security of citizens, that it reduced civil liberties. When we're at threat, most Americans think it's worthwhile, but somehow a reduction in freedom doesn't seem unreasonable for a reduction in fear. But folks like the ACLU criticize the law for infringing on privacy, for violating due process, for being discriminatory. Some members of Congress tried to repeal parts of the Patriot Act, but it was reauthorized under Bush and Obama. In the delicate balance between security and freedom, on which side should we err? Obama stopped the practice of waterboarding, but Americans are more willing to tolerate reductions of freedoms when they come at the expense of non-US citizens. The balancing of public safety with individual rights is complex. We could likely ensure more from safety from threats if we gave up all freedoms. If government could monitor all movements of all of us, they'd know who would endanger others. But without civil liberties, we'd have no protection of government from government itself. How do we resolve conflicts about rights? This is often politics at its messiest, and there are many involved: the courts, Congress, the president, and the people themselves. One of the jobs of the courts is to arbitrate disputes among things like rights. The Supreme Court is usually the judge of what is fair, but the rulings often change as the membership of the Supreme Court changes. They're humans too. The founders wanted them to be above the political fray, but they're still subject to lots of political pressure: the ideology of a president who appointed them, the influence of public opinion, the media. At times in our history, the Supreme Court has championed what seems like the underdog interest that fights the mainstream of American public opinion. For example, ruling in favor of someone who won't salute the flag because of his religion. At other times, the Supreme Court has favored the interests of big business over the rights of the ordinary. For example, putting the stamp of approval on World War II incarceration of Japanese Americans in internment camps, which we have since apologized for. Sometimes Congress chooses to stay out of disputes about rights, and sometimes it takes decisive action to limit or expand rights. Sometimes Congress protects rights, for example, the Civil Rights Act. The president can be involved by lobbying the Supreme Court to encourage outcomes they favor. In the 1950s, Eisenhower was reluctant to enforce desegregation in the South because he thought it was up to the states and not up to the federal government. But JFK chose to be more actively involved and sent Congress a bill on civil rights in 1963. What about the people? Americans sometimes use the courts to sue for what they perceive to be their rights, but often we act in groups. The ACLU, the goal is to defend liberties of Americans, whatever your ideological position. Other groups, the NAACP, the Sierra Club, AARP, NRA, they engage in fundraising and PR to publicize their views, to work to influence government directly by meeting with lawmakers and testifying at congressional hearings. A group effort magnifies a voice and can be considered considerably influential. The Bill of Rights had a stormy birth. There was some controversy about whether a Bill of Rights was necessary. It deepened the split between Federalists and Anti-Federalists during the founding. Controversy didn't end once it was added as the first 10 amendments, and in fact, over a century passed before the Supreme Court agreed that at least some of the restrictions imposed on the national government should be also applied to the states. But why is it valuable? The Federalists argued that the Constitution itself was a Bill of Rights, and the individual rights were already protected by many state constitutions, and to add to the list of powers the national government did not have was dangerous, and it implied the government had every other power, which we talked about before, which was spelled out by Hamilton in Federalist 84. Madison agreed at first. He said this was a nauseous project, but then came to agree with the Anti-Federalists, such as Thomas Jefferson, who wrote, "A Bill of Rights is where the people are entitled to what the people are entitled to against every government on earth. The government is limited in principle by popular sovereignty, the authority of people. So it couldn't hurt to limit the practice, and specific list of rights would give the judiciary a better check." So some of the rights protected in the Constitution are things like habeas corpus, the right of an accused person to be brought before a judge and informed of the charges and evidence against him or her. Bill of Attainder, laws under which specific persons or groups are detained and sentenced without trial. Ex post facto laws, laws that criminalize an action after it occurs. Citizens of each state are entitled to the privileges and immunities of the several states. Incorporation. So the Supreme Court, we incorporated the Bill of Rights after incorporation. That was the Supreme Court action that made the protections of the Bill of Rights applicable to the states. But not all rights necessarily qualified for incorporation. The Supreme Court had to consider each right on a case-by-case basis to see how fundamental it was. Currently, almost all rights have been incorporated. Incorporation is a judicial creation, not an absolute constitutional principle. What the Supreme Court creates can also take away. When religion and politics mix, the stakes are high, passions are deep, and compromise is difficult. The United States has been spared a lot of violence because of the First Amendment protections, but it isn't without controversy. It does establish general guidelines for which most people can agree and says the courts are areas where you can address your concerns. Perhaps a constitutional battleground, but they have kept the United States from becoming a literal battleground by deflecting religious conflict to the courts. Founders based their view of religious freedom on two arguments. First, that history has shown that linking church and state can have negative impacts on secular life. It puts all individual freedoms in jeopardy, and it reduces population to subjecthood. If the government's merely an arm of God, what power can the government be justified? Madison feared that religion could have a divisive effect if it became linked to the government. And then secondly, the effect politics can have on religious concerns. They worried that spiritual purity and sanctity of religion would be ruined if it was mixed with the worldly realm of politics that emphasized power and influence. So the Establishment Clause. This is the First Amendment guarantee that the government will not create and support an official state church. There are separationists who support a wall of separation between church and state, and accommodationists. These are supporters of a government non-preferential accommodation of religion. They say that states shouldn't be separate from religion, but rather accommodate it without showing preference for one religion over another. They argue that the First Amendment shouldn't prevent prayer in schools and posting of religious documents in public places, and teaching of the Bible story along with evolution. Adherents claim that a rigid interpretation of separation of church and state amounts to intolerance of their religious rights or the unjustified hostility towards religion, as Supreme Court Justice Anthony Kennedy had said. A lot of Republicans, Bush, Reagan, share this view. Some judicial rulings on the Establishment Clause. The U.S. practice stands somewhere between those two views. Congress opens with a prayer, but the school day does not. The Supreme Court leans a little bit towards a separationist stance, but we are becoming more conservative. The Lemon Test. You guys, I took an entire class on First Amendment law in law school, so we'll wrap this up quickly. Is a three-pronged test used by the Supreme Court to determine whether the Establishment Clause is violated. It's based on a 1971 case called Lemon versus Kurtzman. It says the law must not foster an excessive government entanglement with religion. That's the test that the Supreme Court puts on these. Free Exercise Clause. The First Amendment guarantee that citizens may freely engage in the religious activities of their choice, but what about when religious beliefs against killing clashes with compulsory military service during war? What about when religious holy days are ignored by state legislation and the days on which an individual should be expected to work? In 1940, there was a difference between a freedom to believe and a freedom to act on these beliefs. We can believe whatever we want, but freedom to act is subject to government regulation. Police power is the ability of the government to protect its citizens and maintain social order. If a state needs to regulate behavior, it may. Compelling state interest test. If a fundamental state purpose which may be shown before the law can limit some freedoms or treat some groups of people differently. Concerns over religious freedom grew after Obamacare. They required employer-based health insurance to provide birth control coverage. In 2012, Hobby Lobby sued about this, and it was decided that corporations that are not publicly traded did not have to provide this coverage. If it violates the owner's individual religious beliefs, some have affirmed rights for corporations and some for individuals. Among the most cherished of American values is the right to free speech. Congress makes laws abridging the freedom of expression, and we tend to restrict speech we don't like, admire, or respect. The challenge is to protect the speech that we don't like, the speech that we despise. Why is freedom of expression valuable? It's important for us to participate wisely, the need to be informed, to have journalists be a watchdog check on government. There's a danger of setting a precedent of censorship. And then, as John Stuart Mill said, the free traffic of all ideas, those known to be true as well as those suspected to be false, is essential in a society that values truth. We must allow expression of all ideas to discover truths previously believed to be false. Sedition is speech that criticizes the government and promotes rebellion, and has long been the target of restrictive legislation. Though the founders were in a daily practice of criticizing their government when they were in the process of inciting revolution, but they feared that if the shoe was on the other foot, they would be far less willing to encourage dissent. Some early restrictions on speech. The Alien and Sedition Act outlawed any false, scandalous writing against the government. State governments in the South punished speech advocating the end of slavery. By World War I, freedom of speech and press were a sham for those who challenged the status quo. The government clamped down hard on people who promoted socialism, even labor unions. In 1971, Congress passed the Espionage Act, which made it a crime to engage in any disloyal, scurrilous, or abusive language about the government. There are sweeping prohibitions like this that make it impossible to arrest people on the flimsiest of pretexts. So what's the role of the Supreme Court here? They have something called the bad tendency test. If this is the rule used by the courts that allows speech to be punished if it leads to punishable actions. It's pretty easy for a prosecutor to meet, so most convictions here are upheld. And then the clear and present danger test, the rules used by the court that allows language to be regulated only if it presents an immediate and urgent danger. Senator Joseph McCarthy conducted investigations of American citizens to search out communists. The House Un-American Activities Committee doing the same thing. Many careers and lives are ruined by suspicion of communism. And then there was something called the imminent lawless action test. This was the rule used by the courts that restricts speech only if it's aimed at producing or is likely to produce imminent lawless action, which continues to be our standard for regulating political speech today. Many forms of expression go beyond writing. Should they be protected? When is an action a form of expression? Burning a draft card, wearing an armband to protest, torching the American flag? The Supreme Court generally is willing to allow the regulation of symbolic speech than of speech alone, especially if the regulation is not a direct attempt to curtail the speech. What about obscenity and pornography? This has probably presented the Supreme Court with its biggest headaches. In 1964, Justice Potter Stewart famously could only conclude, "I know it when I see it." Whether obscenity should be protected speech raises fundamental issues, including defining what is obscene. One man's vulgarity is another man's lyrics. What about fighting words and offensive speech? Fighting words is speech intended to incite violence. The Supreme Court has ruled that this can be regulated, but it rarely upholds legislation designed to limit fighting words unless the law is written very carefully and specifically. It must produce a clear and present danger of serious substantive evil that arises far above public inconveniences, annoyance, or unrest. Political correctness is the idea that language shapes behavior and therefore should be regulated to control its social effects. This movement swept the country in the 80s and 90s and on college campuses. After 9/11, some conservatives treated any criticism of the United States as something close to treason, and commentators who disagreed needed to be careful or they could be boycotted. Obviously, the 2016 election, the Republican primary narrative was that overly sensitive liberals have stifled people's opinion to express themselves. All right, what about freedom of the press? There's something called prior restraint. This is censorship or punishment for the expression of ideas before the ideas are printed or spoken. Libel is the written defamation of character. The verbal defamation is called slander. New York Times versus Sullivan said that an individual, when suing for libel, must show that a publication acted with actual malice, not just evil intent, but that it acted with knowledge that it was false or published with reckless disregard for whether it was false or not. This extended to public figures such as celebrities and political candidates, anyone whose actions put them in the public position. You also have the right to a fair trial. The media coverage often leaves it difficult to find an impartial jury, but there's also a public right to know. The Sixth Amendment promises a speedy and public trial. Journalists often think this is meant that proceedings should be open. Courts are reluctant to uphold gag orders that impose prior restraint on the press. There is conflict between authors and creators of material to claim copyright of work and the public who wants to access this work without paying full fare for their use. I think we're still dealing with this a little bit. I dealt with this a lot when I worked on Capitol Hill. The Stop Online Piracy Act, and PIPA, the Protect IP Act. It required internet providers to monitor their users and block access to international sites that share files. A lot of companies opposed this and said it would require them to censor their users and stifle free speech and innovation. A lot of sites went dark and protested the bill, and it effectively killed the legislation. So how to protect IP rights on the internet still remains unsolved. The right to bear arms. This is a rallying point for those who want to engage in sporting activities involving guns, those who believe firearms are necessary for self-defense, those who believe an armed citizenry is necessary to check government that might become tyrannical, and those who don't believe it's the government's business to make decisions about who can own guns. There are various kinds of gun controls that have been passed at state and local levels, but the NRA keeps it to a minimum at the federal level. Why is the right to bear arms so valuable? It's the chief source of national stability in early America. It was the state militia system. They needed armies of able-bodied men who could be counted on to assemble with their own guns to defend their country from external and internal threats. The Second Amendment was designed to guard against the tyranny of the federal government. Some arguments in defense of the Second Amendment today. First is that hunting and other leisure activities are important to American culture, and restricting any of them, even assault weapons, is the start down a slippery slope. The second is that possession of guns is necessary for self-defense. Gun control would mean that only criminals who could get guns on the black market would be armed, and life would be even more dangerous. And the third is that citizens should have the rights to arm themselves to protect their families and properties from tyrannical government, just like the revolutionaries did. And the fourth is that it's not the government's business to regulate gun use. Honestly, the arguments against the right to bear arms, they have really struggled to come up with a single compelling counter narrative of their own. They argue that none of the rights of Americans, even fundamental ones like speech and press, is absolute. So why should the right to bear arms not carry exceptions? The irony of claiming the protection of the Constitution to weapons that could be used to overthrow the government is that the government protects. It's a little ironic there. Some of the rights of we have rights of criminal defendants. Half of the amendments in the Bill of Rights are devoted to protecting the rights of people who were suspected or accused of committing a crime. There was concern for founders who feared an arbitrary government that could accuse and imprison people without evidence or just cause. A person is innocent until proven guilty. This comes from our English roots, and we have a due process of law. This is the guarantee that laws will be fair and reasonable, and that citizens suspected of breaking the law will be treated fairly. The founders were really sensitive to unreasonable searches and seizures because the King of England had the right to order the homes of his subjects to be searched without cause, looking for any evidence of criminal activity. So the Supreme Court interprets the Fourth Amendment to mean that a person's home is private and can't be invaded by police without a warrant, obtainable only with good reason to think criminal activity lies within. There are a few exceptions to search warrants. Automobiles are a special case since by their nature they're likely to be gone by the time an officer gets a warrant. They can be searched without a warrant if there's probable cause to think that a law has been broken. The Supreme Court has gradually widened this to include luggage in the car. Wiretapping and electronic surveillance is a little more difficult. Search was understood to legally require some physical trespass, and seizure involved taking some sort of tangible object. The Patriot Act and honestly Katz in 1961 made it easier to get warrants. What about a cell phone? Part of the content of what's in your pocket can be legally searched. In 2014, John Roberts, the Supreme Court Chief Justice, said that an average smartphone user, this is in 2014 too, so this is a while ago, has 33 apps that can form a revealing montage of the user's life. Phones are mini computers that contain the same amount of information about us that our houses traditionally contained. Just as houses cannot be searched without warrant, now neither can cell phones. But warrants aren't hard to come by, so people who store information on their cell phones should be cautious. Honestly, I don't feel like I have any rights to what is on my cell phone. I mean, I feel like it's out there and anybody, I think that's something that we kind of all grow up knowing now, that if you type it, it is not yours anymore. What about random testing for drug or alcohol use, blood or urine tests? Is this an unreasonable kind of search? Maybe, but the Supreme Court allows them where a violation of privacy is outweighed by a good purpose, like discovering the cause of an accident, preventing drug use in schools, preserving public safety by requiring random drug tests of an airline pilot. The exclusionary rule. This is the rule created by the Supreme Court that evidence seized illegally may not be used to obtain a conviction. Even if the police have a concrete evidence of criminal activity, if it's obtained unlawfully, it cannot be used. In England, it can be used, but a defendant can sue the police. This tries to deter misbehaving police, but not allowing the guilty people to go free. The American exclusionary rule can help criminals avoid punishment, and it deters the police. We've carved out a good faith exception where evidence is admitted to a criminal trial, even if obtained illegally, if the police are relying on a warrant that appears to be valid at the time, or a law that appears to be constitutional that may have turned out to be defective, or a warrant obtained in error. Fifth Amendment provides for protections for individuals including not being a witness against yourself. This expands to a grand jury, legislative investigations, and police interrogations. 1966 Miranda versus Arizona, police had to inform suspects of their rights to remain silent and to have a lawyer present during questioning. Your Miranda rights. If a lawyer shows that a defendant was not read his Miranda rights, likely the exclusionary rule, it could result in a police interrogation not being admissible to court. This resulted a lot of times in criminals going free, though evidence was there to convict. In 2000, Miranda was upheld as an established part of the culture. You have a right to counsel. The Sixth Amendment says that you have a right to a lawyer to be present during questioning. Your right to counsel is now seen as essential, but it's often violated because of overworked public defenders or state laws limiting who can receive court-appointed counsel. The Eighth Amendment protects against cruel and unusual punishment, but what is cruel and what is unusual? The Supreme Court says not all unusual punishments are unconstitutional, but because all new punishments, like electrocution, lethal injection, are unusual when they first appear, but they may be more humane than old punishments like hanging or shooting. Overall, Americans still do favor capital punishment. What about the right to privacy? The right to privacy is valuable, but it's not spelled out in the Bill of Rights. It goes hand in hand with the founders' insistence on limited government. They want a government to be not too powerful and to not interfere with individual citizens' life, which implied a right to privacy and assumed it, but it was not made explicit. Is it so obviously desirable that we should be left alone to do what we want that it scarcely needs a defense? The right to privacy is without limits in anarchy and the absence of government altogether. The interest is in preventing some types of behavior like murder, theft, and rape, but what about more subtle behaviors that don't directly affect the public safety, that have serious consequences for the good, like prostitution, drug use, gambling, riding a motorcycle without a helmet? Should this be private behavior? Should this be private behavior, or should it be regulated by the state? The Supreme Court didn't actually discover privacy, and whether a right still exists is controversial. All of the Bill of Rights includes limitations and contradictions, but the right to privacy is the least certain of all. Reproductive rights. Until the Civil War, abortion bans were uncommon. Most states allowed abortion in early stages of pregnancy, but the opinion turned after the war, and by 1910, every state but Kentucky made abortions illegal. In the 1960s, legislation was becoming more liberal, but abortions were still mostly unobtainable. Obviously, Roe versus Wade in 1973 said that a right to privacy did encompass the right to an abortion and tried to balance a woman's right to privacy and reproduction with the state's interest in protecting human life. And if you've been following what's going on in Texas, this follows right along with this. Congress has failed to pass a constitutional amendment banning abortions. They have passed over 30 laws restricting access in various ways, such as limiting federal funding via Medicaid. Abortion has become a very partisan issue. The Christian right make up a lot of the Republican Party. The Republicans usually include a commitment to abortion under their presidential party platform. This directs efforts to the states. There are other rights to think about. Gay rights. If there's a right to privacy, who should be included under it? What about the right to die? Is the right to die protected under the right to privacy when you have somebody who wants to terminate their medical treatment? Do individuals have the right to assistance in ending their lives when they're terminally ill and in severe pain? Should a patient decide? Would it violate a doctor's Hippocratic oath? The Supreme Court has said it has been left to the states. We've talked a lot about the Bill of Rights, but what would a Bill of Obligations look like? Obligations are the flip side of rights. For every right guaranteed, there's a corresponding duty to use it. Provisions for elected office imply a duty to vote. Congress is authorized to collect taxes, and citizens are obligated to pay those taxes. In Europe, such obligations are explicitly extended to include providing for welfare of those who cannot take care of themselves. Tax burdens are higher, and sometimes the obligation to vote is legally enforced. How much fulfillment is enough? We must obey laws most of the time. If we don't pay all of our taxes, we pay most of them. If we don't vote, we get involved in other ways. We are getting by as a nation for now, but we should perhaps consider the long-term consequences to a democratic republic if the emphasis on preserving civil liberties is not balanced by a corresponding commitment to fulfilling political obligation. As you guys know, I think it's incredibly important to vote. I think that's something that we should always be a part of. We need to preserve our civil liberties, and voting is a great way to do that. Well, we're thinking about the balance between security and freedom. How do we err? Do we want a more secure country? Do we want a more free country? These are all things to think about when we're talking about our fundamental American liberties. Okay, that is all for that chapter. I'll be back with the struggle for equal rights, and then don't forget your first exam will be posted on Monday, September 20th. Always email me if you have any questions. All right, thanks.